able to intervene through physical means in the classroom because they are dealing with complex classroom situations and children with complex needs. We feel that these concerns are very important, and the Bloc Québécois is taking them into account. There's also the Bender case from 2023, so very recent. This was a decision on an appeal in an Ontario court that spoke of a teacher that was accused of assault against a child. I'm sure that you all know what happened in this decision. The Supreme Court said that without Section 43, Canadian law in terms of assault would criminalize this use of force for the correction of a child, such as forcing a child to sit down for 5 minutes to calm them down. Criminalizing this type of behavior does not seem founded. And this can sometimes break up families.
This is ridiculous. This isn't about safety.
So, Madam Chair,
this is about using physical punishment.
There is also the other aspect of this. In Japan, there was a recent law passed.
Why do teachers get more
that came into force in 2020 that stated
authority over a child shall not discipline the child by inflicting corporal punishment upon him or her, or by taking other forms of action that go beyond the scope necessary for the care and education of the child. Alors, moi, je pense que l'article 4...
So I feel that Section 43 should be revised, given the evolution of law of Canadian society.
No.
And so I would like us to modify it, but I think that it would be a serious mistake to completely repeal it. And this would not be in line with different movements throughout the world in the field of education. And the correction of children. So I will briefly read the amendment. A person who exercises parental authority or to whom that authority has been delegated, so it could be parents or teachers or those caring for the child, must not subject a child under their care to any corporal punishment or to any other violence. However, the person may use force that is reasonably necessary for the safety of the child or of a third party or for the child's upbringing. So with this, we would be allowing teachers or anyone who is caring for the child
Why do teachers get
to
more
discipline the child through reasonable force?
Or a parent,
so for example, the case of the Supreme Court, the example of a child needing to sit down for 5 minutes or forcing a child to get up from the table because they are a danger to their classmates, or if there's a fight between students and the teacher needs to be able to intervene with reasonable force to break up a fight. We oftentimes can't break up a fight by simply saying, we would really appreciate if you would stop fighting. Of course, Madam Chair, we would like things to work that way, but that is not reality. That's not how we educate children. Anyone who has children knows this. Now, of course, no one would be able to use corporal punishment. Taking a stick and hitting the child is unacceptable, and nobody believes that this should be allowed. Using reasonable force to protect the child and the children surrounding them in certain cases is certainly justified, and this is what is applied throughout the world. I quoted a case in Japan. I quoted the Bender case that was at the Supreme Court of Canada. And we have listened to different school teachers who understand the situation, I would say, better than me and better than all of us around the table, respectfully. We've heard from teachers' associations, and all of these groups have told us that they recommend the approach that we're suggesting here. So I think that this will allow us to respect everyone's concerns. And I'd also like to say that we are taking into account what's best for children, for parents, and school teachers throughout Canada. Thank you, Madam Chair. Thank you.
Next, we have Madame Gladue.
Thank you, Chair.
Okay, yeah.
Definitely, I agree with Monsieur Fortin that we did hear testimonies, numerous testimonies from teachers that talked about the increase of violence that they're seeing and the importance of retaining Section 43. So I agree with him that it would be a big mistake to take it out altogether. But in fact, the Supreme Court did quite an excellent job of defining with clarity the scope. And so if we support BQ1, we can't support CPC1, which actually is the more fulsome Supreme Court decision put in to clarify. So for that reason, I can't support this, although I do agree that we need to retain Section 43 and capture with clarity the Supreme Court decision.
Okay. Mr. Maloney, and then Mr. Moore, and then Mr. Gitt, and then yep.
Thank you, Madam Chair, and I want to thank Mr. Fortin. I agree almost entirely with everything you said, but I will not be supporting your amendment, nor will I be supporting, if we get to that stage, the second amendment that's been put on the table, and I'll tell you why. I will be supporting the bill as proposed because it addresses call to action 6, which I think we all agree is very important and something that needs to be dealt with. But I also agree with you, as I said, Mr. Fortin, because we did hear some very compelling evidence from multiple teachers groups from Quebec and from across Canada, and they raised very legitimate concerns, and we need to listen to those concerns. But I don't feel it's appropriate to address that in the context of Section 43. So as a result of discussions my colleagues and I have had on this side of the table with the minister, Minister Varani has given us his assurance that he will be bringing forward separate legislation at some stage to address the concerns raised by the teachers in a separate section of the criminal code, in keeping with the spirit of what they proposed by all of the witnesses that appeared here. So I think that's a solution to what you're proposing and to what the Conservatives are proposing, while adhering to the spirit of call to action 6. Thank you.
Mr. Moore?
Well, thank you, Madam Chair. Actually, that's kind of a shocking and troubling development. This piece of legislation, should it pass, which would be a big mistake, based on the testimony that we heard around parents and around teachers in particular, teachers who, even the Liberals' own witnesses, came to this committee and said, removing this section will put teachers at risk and by extension put students at risk, because of teachers then being told by their superiors not to intervene in any physical conflicts that are happening between students and any students who are being unruly in the classroom. The advice that we heard that would be given to teachers by their administration, by their unions, would be not to intervene at all without the protection of this. That's not my words. That's the words of witnesses, some of whom were Liberal witnesses. So the way this works is, should this bill pass this committee, pass the House, and then pass the Senate, it becomes law, irrespective of what Minister Varani has said he would do. It's quite unprecedented, I would say, to say, don't worry about passing that law, because at some point, of which none of us, I'm certainly not privy to, I don't know if anyone on this side of the table is privy to, at some point, we're going to fix the mess that passing this bill would create. So what we've heard here today is Minister Varani even acknowledges it would be a mistake to have the law in Canada be such that Section 43 does not exist without any of the protections that are needed for parents and teachers. Minister Varani has apparently given assurances that at some point he's going to bring in legislation.
Could you imagine
But that legislation
if we
should not
stop
pass
hitting kids?
before this bill.
What
Then
that
this
might
bill
mean?
will
Could you
stand
imagine?
alone, and the law will, the Section 43 will have been struck down, and parents and teachers will no longer have the protections afforded by it. So, contrary to the notion that we might somehow feel comforted by this news, I'm actually quite alarmed by it, because it means that Minister Varani's advice from his department is that passing this legislation would leave gaps in the law and put teachers at risk. Otherwise, why on earth would he commit to legislation to address teachers' concerns? The time to do that is now. There's government legislation, there's private members' bill. A private members' bill has the same effect as government legislation. Once it's passed, it is the law. So it makes no difference whether a private members' bill amends the criminal code or if government legislation amends the criminal code. If the criminal code is amended by this parliament, then that is the law of the land. And I think hearing what Mr. Maloney has just said reinforces my position, and I've heard from Mr. Fortin on his motion. I'm unable to support his motion because, as you said, Chair, should his motion pass, then our conservative motion could not be dealt with. Our conservative motion, and I don't want to get ahead of myself, but I'll just briefly state why I prefer it to Mr. Fortin's. Our conservative motion reestablishes in the code what the law is today, following a leading Supreme Court of Canada decision which considered Section 43, upheld it constitutionally,
He's
and
citing 2004,
and defined Section 43
almost 20 years ago.
and what it means and what it does not mean. And we heard really outrageous
Could you imagine
illustrations
being a
and
parent trying to
examples by
break
the proponent of
cycles
this
and
bill.
having a law that
And
supports
from some
20 years ago?
we heard from some witnesses
How is it
about
helping parents who are doing such hard
a
work?
paddle being used, about a student being punched in the face. Anyone who's taken the time to read the Supreme Court decision from 20 years ago would know that those actions
From
are
20 years ago.
absolutely not protected by Section 43 today. Section 43 has been narrowed and defined by the Supreme Court, and the conservative amendment will put into the code the language that the Supreme Court used. So I prefer our amendment. I think our amendment is more robust. Our amendment is certainly constitutional because the very language of our amendment has been upheld by the Supreme Court of Canada. So I prefer our amendment, and therefore I have to vote against Mr. Fortin's, but we'll get to that if we get to it. Thank you, Madam Chair.
Thank you. Mr. Garrison?
Thank you very much, Madam Chair.
Come on, Garrison.
I want to speak a little bit generally, then I'll come specifically to the amendment. I am concerned when around this table, we don't take seriously the commitment that all of us made to truth and reconciliation in this country. And recommendation 6 was carefully considered by the Truth and Reconciliation Commission. And I believe all of us around this table have expressed support for those calls to action. And so if we go to calls to action and say we support them, yes, but that's not really reconciliation. That's substituting our judgment for the judgment of Indigenous people on the impacts of this section on Indigenous communities. We may have a second and competing concern here, which is that of teachers. And I am glad to hear Mr. Maloney say there's a commitment to solve that problem, but we can't solve that problem at the expense of reconciliation in this
Absolutely.
country.
Yay.
So I think it diminishes
Garrison.
the
Round of
arguments that were
applause.
made about the impacts of this section on
Yay.
Indigenous communities to say that we can't proceed without protecting some other group at this point. On the specific amendment, my problem with Mr. Fortin's amendment is the last phrase, which says, or for the child's upbringing. So if you just take it most simply, it says reasonable force can be used for the child's upbringing. That was exactly the problem in
Yes.
section 43, and that's why I believe this is out
Yes.
of order. It restores the very
Yes.
problem that the call to action tries to take
Garrison.
away, and that's the idea that reasonable force can be used
We don't
for a
need
child's
any
upbringing.
force.
So for that reason, specific
That's what I
reason,
do
I'm
every
voting against
day.
this
Help
amendment.
parents.
But I would also urge all members to pass this bill to repeal the section unamended, which was the purpose and intention of the Truth and Reconciliation Commission, and would uphold our commitment to
Yes.
reconciliation in this country. Thank you.
Yes.
Mr. Van Popta, please.
Good. Thank you. Thank you, Madam Chair. I too am troubled by this last minute development of the governing parties saying that they will now introduce new legislation around corporal punishment. So we haven't seen it at all. We're trying to have a fulsome debate here at the Justice Committee. And now we have a promise of some new legislation that might come down the road at some time. So, you know, that the timing just doesn't contribute to a good, productive discussion. And I'm deeply troubled by that. The government has had lots of time to think about this in response to the Truth and Reconciliation Commission report, which has been with us for many, many years. And here at this last minute, they're dropping it on us and telling us that they're not going to support common sense amendments that both parties are putting forward. And I want to speak to Mr. Fortin's motion and his talk in support of it. I agree with much of what he has said, but I believe that competing motion CPC number 1 is better in that it codifies a very thoughtful decision from the Supreme Court of Canada of 20 years ago, which explained what Section 43, I think it is, does and does not do. And I think with that clarification, people can rest assured that Section 43, which is really itself a codification of the common law defense against charges of assault for teachers and parents. And I think it's a shame that Parliament at that time, 20 years ago, did not introduce new legislation to amend Section 43 to further explain that. And I suspect that had that motion, that amendment been made in response to the Supreme Court of Canada decision of 20 years ago, that the discussion around Truth and Reconciliation Commission recommendation number 6 might have been quite different. I think without the without that amendment and without reading in the clarification from the Supreme Court of Canada, many people have been confused about the difference between, as one person had said, that it does not adequately distinguish between physical punishment and physical abuse. So what happened at residential schools was physical abuse, not physical punishment. And that's what the
Did he just say there's a
Truth and
difference between
Reconciliation
physical punishment and
report
physical abuse?
recommendation number 6 talks about.
Um,
And had Section
does he
43 been
understand like the
clarified
legal
in
reporting
response to the
laws in
Supreme Court of
Canada?
Canada decision,
When
I
a
think that
child is
discussion would have been
hit,
much different.
that's
I
reportable.
look at
Is he out hitting
CPC
his
number
kids?
1,
Does
and
this guy have
hopefully
kids?
we're going to get to it.
Does he have kids?
But
Who are his children?
it basically codifies,
We need
it
to
goes
check
step by
on his
step through what
children.
the Supreme Court of Canada said and just captures all those, the main highlights. And it also, CPC motion also makes a clear reference to school teachers in Section 4, and that is in response to evidence that we received from educators here at this committee. I think CPC is a more responsive motion to testimony that we received at this committee and to jurisprudence that is developed around Section 43.
Mr. Housefather?
Thank you very much, Madam Chair. So I want to start by saying that I'm very much of the mind coming out of committee that we need an amendment in a different section of the code to deal with the very valid concerns that teachers brought and concerns that others have brought related to parental authority. But I'm also very mindful of the fact that repealing Section 43 itself is a very important goal of the Truth and Reconciliation Committee, and we don't achieve that goal by replacing Section 43. That amendment, even as the teachers themselves recommended, has to be in a different section of the code. And we're not able at this committee to have a receivable amendment, because I had drafted one that is similar to the Conservatives' amendment that reflects the Supreme Court judgment, that would be receivable because we can't amend a different section of the code than the one that is actually being debated at committee. So I didn't submit it because I figured that it's not receivable, there's no point. I'm very comforted by the fact that the minister has undertaken to put forward an amendment to a different section of the code that will deal with the concerns, the very valid concerns that teachers have raised. And I do think that not having the codification of the Supreme Court interpretation of the original section is a problem. So I hope that what we can do today is pass the bill, have a later coming into force date of the bill, and work to ensure that the minister tables and we get something passed that comes into force simultaneously with this bill. That would be my hope. And as to the amendment itself, I agree with Mr. Garrison's comments about the last part of Mr. Fortin's amendment. So I wouldn't have supported this amendment regardless. Thank you, Madam Chair.
Thank you. Monsieur Fortin?
Merci, Madame la Présidente.
Thank you, Madam Chair. I'm also somewhat concerned. Now, I'm happy to hear that the minister has the same concerns as us and that he would like to amend the criminal code. But what I've understood at the end of the day is that we're improvising a little bit. We're sort of like intern legislators who are learning on the go. And that concerns me. And I have much respect for the Minister of Justice. I understand your concerns and I want to modify the criminal code because of that. But when are they going to do that? We're going to be in elections in a year to a year and a half. As we wait, Canadians will find themselves in, I don't want to call it a gray zone, but things will not be very clear and it will be a dangerous space to be in. We all recognize this. I would say that generally, just about everyone, I can't necessarily speak for the NDP, but the Liberals, the Conservatives, the Bloc Québécois, we all understand that it would be a mistake to simply repeal Section 43. So I have a suggestion. The Conservatives have their own suggestion. Now we can discuss which one is the best, but the Liberals are simply saying, we agree with you, but we're going to do this when we feel like it. Madam Chair, rather, I do not think that this is acceptable when we have been tasked with such an important mandate for the entire Canadian population. What are we going to say to Canadian teachers, parents,
What
who
about
will
the
find
kids?
themselves in
What are
a
you going to say to
situation
the
where
kids?
they may
That
be
matters. It's always about
charged
the
with
adults.
a crime that all MPs recognize should not be considered a crime? And we'll be there saying, well, we agree with you, but, we have other things to do right now. Not only do we have other things to do, but we decided to abolish the rule that was already established that would have protected you. So I apologize, but once again, it seems that we are simply improvising. We're getting here this morning and saying, yeah, we agree with you, colleagues. And, I'm proud to say that I'm open-minded and I can change my mind. I may be completely against you, but if you speak to me in a way that changes my mind, then I can evolve. So, but what's happening here is we're recognizing that what we have here is not correct, but we're going to move forward anyway. Madam Chair, my question is, why are we going to move forward in a direction that we know is not the right one? I'm not happy to see this. The Truth and Reconciliation
about you,
Commission
buddy.
report
It's about the kids.
raised concerns that everyone shares, and we want to respond to these concerns. But right now,
There's no
the
but.
government
No but.
is not committed to doing anything because we have Indigenous representatives who have said, our Indigenous children have been victim of abuse in schools, and this is not okay. But now we're saying we're going to change the law for everyone,
Yeah.
not just for teachers, but for parents,
Yes.
anyone with parental authority. And I don't
Yes.
think that the Indigenous community would necessarily be in agreement with this.
Yes, they would. The whole
course.
idea is to lead
Indigenous
us.
children have faced
Indigenous
things they should have
people
never
are
faced.
absolutely leading us and decolonizing. It's not
So
just
we're
about
trying to respond
keeping
to
them safe.
the
Of course it is.
report, but we're also trying to respect our colleagues, respect Mr. Julian from the NDP.
We're not here
Mr.
just to make laws
Julian
about
is
Indigenous
suggesting one
people,
thing.
Mr. White Guy.
The government seems to want to be able to take action whenever they want. The government says, "Oh, Mr. Julian tabled this. We're going to follow what he wants to do." The NDP is listening to a few Indigenous representatives, and then we're going to change the law for everyone. We all agree that this would be an uncomfortable situation.
Yes, for everyone. Yes.
It feels as though the government is simply trying to satisfy the NDP to get their support. But we need to get to the heart of the problem that was really raised in the Truth and Reconciliation Commission's report. I don't think the government is really seeing that. So we risk to enter a situation that would be worrisome for all Canadians. And the Liberals stated that they recognize this. They want to do something elsewhere in the code. Okay, but we need to be serious about this. And so if we want to amend it elsewhere, then let's keep Section 43 at the very least, or let's amend it in the
Who's
way
this
that
guy's
the
kids?
Bloc or the
This guy's
Conservatives are
kids?
suggesting.
We need to check on his kids too.
And in the future, in a new bill, they could say we're going to repeal Section 43 and modify the code elsewhere, and then we could implement a quality solution to the problem and avoid putting us into this bad situation for all Canadians, for teachers, parents, and children. Nobody is going to win with this bill.
Yes, the kids
Thank
will
you, Madam
win.
Merci, Monsieur Fortin. Alors,
Thank you, Mr. Fortin.
s'il vous plaît.
Mr. Moore?
Thank you, Madam Chair. So here we go again. The Liberals are trying to be on both sides of the same issue, and that is why we're in this situation. You take what was said today and what becomes very clear. Section 43 is where it is because that's where that section has to be. It says that every school teacher, parent, or person standing in the place of parent is justified in using force by way of correction towards a pupil or child, as the case may be. Why is that section there? It is there because otherwise, if you were to grab somebody and take them to the principal's office, if you were to restrain your child, otherwise, if you did that to someone else, that is assault. And that is why it is in that section. So what the Liberals are saying now is for people that want to get rid of Section 43, we're going to get rid of Section 43. For people that recognize that completely eliminating Section 43 is problematic, we're going to put the good parts back in Section 43, just in a different part of the criminal code where no one will notice. That is the outrageous position of this government.
Yeah.
The appropriate, and the opposition parties are doing the homework on this. The NDP brought in the bill. It's a flawed bill. It's trying to accomplish something, but it goes too far, and it would criminalize teachers and parents. The Supreme Court has already considered this issue and not only upheld the constitutionality of Section 43, but very helpfully narrowed it in so that basically every example that was used by the proponent to justify his private member's bill is criminal in Canada. He talked about punching someone in the face. That's criminal. He talked about strapping someone with a paddle. That's criminal. That is not protected under Section 43 as interpreted by the Supreme Court of Canada. So our amendment establishes in the code the language that the court used. The bloc have a different amendment to try to accomplish some of the same goals. But what the government's doing is saying, boy, we want to be able to say we got rid of Section 43, but we know we can't get rid of Section 43. So what we're going to do is we're going to say, yeah, we got rid of it here, but now we're hearing you teachers and parents, so we're going to do something somewhere else. I mean, you couldn't be more crass than that, Madam Chair. Like our job here is to take the bill as presented. I cannot base my actions today on fourth-hand knowledge that maybe the minister told someone who told someone that they recognize this bill's a problem, and at some point, yet to be determined, they're going to bring in legislation to address a problem that this bill creates. If we are not prepared to address the problem that this bill creates as a committee, then we're not doing our jobs. Now, Conservatives have done their jobs. We have an amendment that would uphold the important parts of Section 43, the parts that say that a teacher who's breaking up a fight and physically involves themselves in that fight while one person's maybe being assaulted, that teacher is not going to get charged with an assault. Now, am I making up that scenario? No, those very scenarios have gone before the courts, and the teacher's defense and the reason the teacher was not convicted criminally is because of Section 43. And that is why teachers' organizations appeared in this committee and sat there as witnesses and testified that removing Section 43, as this bill does, would put them in danger, but would also put their classrooms in danger. And that students are in danger if teachers are going to be charged criminally if they intervene in an ongoing assault. Now, we could have other people say, oh, that would never happen. But the only problem with saying that would never happen is it has happened. It does happen. And that's why the teachers were here. So we can only deal with what we have in front of us. And what we have in front of us is a flawed bill and a couple of amendments that would try to improve upon the bill. And we haven't gotten to CPC 1 yet, our amendment, which I'm more convinced now than ever that it's necessary. Now, I had been talking to our witnesses earlier, and I said I didn't have any questions.
He's saying that teachers
and I was being absolutely truthful when I told you I didn't have any questions because I didn't. But now I do. I do have questions now because of the way this debate has unfolded.
Teachers need to use punishment, basically, is what he's saying.
Your understanding, I'll put this to either witness who wishes
and he's
from
saying
the
this
department
because
who
he knows
wishes
that the teachers
answer
are
it
successful,
through you, Madam Chair.
then also parents will be successful.
The proponent of the bill used examples.
And notice he's not talking about kids' rights
in
at
his
all.
opening remarks, at least 4 of them, that my understanding of the court decision would be criminal. He used the example of a teacher punching a student in the face, or a parent punching a child in the face. Your understanding of, through you, Chair, of the Supreme Court decision, leading decision in this case on Section 43, would a parent or teacher punching a child in the face be protected under the code as interpreted by the court?
No, obviously not.
Through you,
But we're not talking about
So thank you for
extreme
your
violence.
question. I think that the Supreme Court majority decision,
It's not
the Canadian
helpful.
Foundation laid out a couple of guidelines to determine what reasonable force is under Section 43. And one of them is that the force should not be applied to the child's head. So in the circumstances that you're talking about, it probably would not result in reasonable force as the child would be struck in the face by a punch.
Okay, so I don't have a ton of these, but I'm going to ask another one. One witness brought a paddle. So applying a big wooden paddle to a child's hand, for example, based on the Supreme Court decision, is that protected activity in Canada?
So again, as part of the guidelines to determine what reasonable force is, what I mentioned, striking the head is one of the examples, but the Supreme Court did mention that force applied with an object would not meet the threshold of reasonable under Section 43.
That's right. So what we have is a bill that the proponent is advertising using scenarios that are criminal already to justify the bill. So the concern that witnesses have, and the concern apparently that the Minister of Justice, Arif Farani, has, is the implication of passing this bill on conduct that is not criminal now. So what kind of conduct is not criminal and is protected by the Supreme Court decision? That is the scenario, Madam Chair, that I expressed to you of a teacher breaking up a fight, a teacher being assaulted. And we heard, and I know you know many teachers, I think one of them was from your riding, or it was at least from your province of Nova Scotia. Teachers increasingly are under threat in the classroom and are having to deal with increasing violence in the classroom. Not my words, that's the words of the witnesses that we had on this bill. So we heard them as conservatives, we heard that testimony, and we crafted an amendment based on the Supreme Court decision that would protect parents and teachers from being criminally charged. This is serious. At a time of escalating gang violence, drug violence, and all the things that are happening, we're dealing with a bill that targets teachers and parents. Let's be clear about that as well.
Yeah.
Because it only applies to Section 43, which this bill strikes down, only applies to parents and teachers. It says every school teacher, parent, or person standing in the place of a parent. So we're not talking about the general public. We're talking about teachers and parents. They are the only people protected from assault charges based on this section of the criminal code, which this bill will strike down. Now the alarm bells are going off, in the department or with the minister, and they realize, wow, the teachers are right. The parents are right. This bill is a problem. But we want to be able to say that we eliminated that clause. So now we have to put that clause somewhere else in the criminal code. And Madam Chair, I mean, that's games, and that's the worst kind of games. And I do have one more question for our witnesses. I know the answer to it, but I want to get their perspective as well. The minister apparently, through Mr. Maloney, has indicated that he will pass at some point legislation. But if this private member's bill passes into law, and the minister doesn't introduce that legislation, or the minister's legislation follows sometime after, are the protections afforded parents and teachers under Section 43
Why do they
in that intervening time?
That's the
are they
weird
not
part.
Lost with the passage of this bill?
Thank you for the question. It is hard to determine what the real impact will be of the repeal of Section 43 in and of itself. The case law has obviously adapted and applied what the Supreme Court has decided and gave as guidelines for the use of reasonable force by parents, persons standing in place of parents and teachers. But the one thing I would mention is that, without Section 43, what we have already, or we have seen in case law, is also we're bringing up certain common law defenses. So you would have de minimis, the defense of necessity, and maybe others could at one point, have recourse to defense of implied consent in those cases. But the fact is that we haven't seen it to the extent as being, they're very specific, those defenses, to certain circumstances. And so it isn't clear to what extent those would apply to the same extent as Section 43 defense currently applies.
That's 100, absolutely, I agree with you 100%. And that is why the case law that you mentioned that has flowed in the last 20 years after the Supreme Court decision upholding Section 43 and narrowing its application, that case law is based on Section 43 being there. With Section 43 gone, if this Parliament decides to eliminate that Section 43, then all of that goes out the window as well. So I think, Madam Chair, I'm more convinced than ever that we need to pass CPC 1, and that we know that there's an agreement with the NDP and the Liberals. This isn't the way to go about things to put parents and teachers at risk. If there's more information about the timing of the passage of this private members bill and the coming into force maybe of some hypothetical legislation from the minister, I think that is really important right now, because the minister apparently wants to be able to go to teachers and say, don't worry, we're looking after you. But we're not privy to that. All we have is the bill that's in front of us. And what the minister has indicated now is those of us that have been saying this is a problem, we're 100% right. It is a problem. So there's going to be some kind of sleight of hand fix that in a less appropriate section of the criminal code, there's going to be an amendment, maybe at some point, that addresses the fallout to parents and teachers of the passage of this private members bill. That's putting the cart before the horse, Madam Speaker, Madam Chair. That's not how we are to conduct ourselves at these committees. So I think based on the legislation that's before us, based on the law as it stands, based on the Supreme Court decision, we have no alternative than to either reject this private members bill or at least pass the protections that teachers and parents need in CPC 1.
Mr. Housefather.
Teachers and parents.
Thank
don't need
you.
protection.
Thank you, Madam Chair, and thank you, as always, to Mr. Moore for his comments. I'm reading now from the draft of the brief, or the actual brief from the Canadian Teachers Federation, because the Canadian Teachers Federation is what we're talking about here. They represent the majority of teachers across the country. They're asking the government of Canada, not the committee, they're asking the government of Canada to, one, ensure the continued protection of teachers and students in their care while respecting the Truth and Reconciliation Commission's TRC calls to action. That is their number one request. Then they're asking us to amend Section 265 of the Criminal Code of Canada. It is not within the committee's purview under this bill, unfortunately, to amend Section 265, or I would have proposed an amendment to amend Section 265. But the government of Canada, to whom they're making the appeal, can amend Section 265 or another part of the code to deal with the very valid concerns raised by teachers. And that is what we have had an undertaking from the Minister of Justice to now do. So in my view, opposite to trying to play two sides or anything, as Mr. Moore is saying, we're actually responding to exactly what the teachers have asked. We're fulfilling the Truth and Reconciliation Committee's call to action. We understand that there are stakeholders that, for whatever reason, symbolically believe Section 43 needs to go from the code, and that was what was in the TRA recommendation. And at the same time, we will be having a bill or part of a bill that will deal with the protection of teachers, which is, again, the committee cannot do in the context of this private members bill to amend a different section of the code that's not referenced in the bill. So I also welcome Mr. Maloney's comments. I look forward to more clarity on it, but I am comfortable that we are actually doing exactly what the CTF asked us to do. Thank you, Madam Chair.
Madame Gladue.
Thank you, Madam Chair. What I would say is that when the Teachers Federation was testifying, and they brought forward this suggestion that they would, take away 43 and put in amendments in the criminal code. They didn't understand that the private members process didn't allow that. And when Mr. Garrison and myself pointed that out to them, I specifically asked those witnesses, if we can't amend the criminal code, then what about Section 43? And they said they would not be happy to not be having that protection. And so again, I think it would be
Exactly. Isn't that
irresponsible
scary?
to take a
Isn't
bill
that
that, as
scary?
Mr. Moore correctly pointed out, has
Teachers
been
would
brought
not be
forward on a
happy.
false premise. You know, the examples that were presented were clearly abuse that's already criminal
That's so
and
bad.
is not what we're talking about in section 43. And then to pull this switch, bait and switch on the truth and reconciliation to say, oh, well, we'll take out 43, but we'll put it in somewhere else. Well, I think that's disingenuous at the minimum. Not only that, I have no confidence that in the time remaining before the next election, that this government can bring a bill. Bills, even if they're not controversial, can take about 18 months by the time they get through the whole process. And we haven't even seen a draft of this bill. So I think that, there's no way that we could responsibly say, oh yeah, we'll pull out section 43 on the off chance that the government gets it right in the legislation that actually gets passed. I think we can't do that. We have to stand up for parents. We have to stand up for teachers and provide them protection until such time that the government actually brings legislation that
No.
could do it in an alternative method. That's my opinion.
Mr. Van Popta?
Good. That will come out of the work of this committee today. If this bill passes unamended, which it seems that the Liberals want to do, then the messaging is going to be clear that this government does not stand with teachers. We had Dr. Kelly here, law professor, give evidence, and she was asked exactly that question. What will be the message if what would be the message to the public of repealing Section 43? She said, I think proponents of repeal hope that the message will be that all forms of physical discipline are wrong and unlawful. And we have witnesses here from the Canadian Teachers Federation give evidence strongly in support of retaining Section 43 with amendments. And they had actually put forward thoughtful amendments to a different section of the criminal code, which would have more or less the same effect as the motions that the Conservative Party is putting forward. And this is what the written submission said. When it comes to education and the safety of children, careful consideration of all eventualities is vital. In its current iteration, Bill 273 ignores the present day realities facing teachers, students, and teachers. We urge you to amend and pass this bill to work forward towards reconciliation while keeping classrooms safe. And they also said, educators are deeply committed to serving children. Protecting students from themselves and from one another is a key component of educators' work in schools. Stopping classroom violence should be supported, not policed. And with repealing Section 43, which is what Bill 273 would do, I think would do exactly that. It would not support schools, but it would bring in police enforcement instead. And I think that is just the wrong way to go. And certainly the Teachers Federation thinks that that would be completely inappropriate. Thank you.
Thank you very much to all members on your thoughtful comments. I am now going to remind you that CPC-1 cannot be moved if BQ-1 is adopted. I will now ask, shall BQ-1 carry? Okay, I hear no's, so BQ-1 is defeated.
Comptez les votes, s'il vous plaît, Madame la
Okay,
Présidente.
Could we please count the votes, Madam Chair?
Merci, Madame la Présidente. Donc,
Thank you, Madam Chair. So BQ1, Mr. Maloney.
Madame Brière?
No.
Monsieur Mendicino? Monsieur Osfader?
No.
Madame Dillon?
Non, Monsieur le greffier.
Si. Mr. Moore?
No.
Madame Gladu?
No.
Mr. Giovanni?
No.
Mr. Van Popta?
No.
Monsieur Fortin?
Oui, oui.
Merci. Mr. Garrison?
No.
OK, merci beaucoup.
Thank you.
Is defeated. I will now go to CPC-1 and ask the member if the member wishes to move it.
Thank you, Madam Chair. I do wish to move it.
Mr. Moore, yeah.
Yeah, and I'd like to speak to the amendment briefly.
Yes, Mr. Garrison?
The same point I had on the last amendment, I'm going to make on this amendment. I believe it is out of order. The amendment repeats the language, if the force does not exceed what is reasonable under the circumstances, which is the exact language from section 43. So once again, it goes against the purpose of the bill, which is to repeal that language. And so I can't understand how an amendment that puts back what the bill intended to remove can be in order at this point. Thank you.
So for the same reasons as I ruled the previous BQ-1, I rule that this is in order. I will ask Mr. Moore to please explain and speak about his amendment.
Thank you, Madam Chair. So section 43, as we heard from witnesses, it provides a defense for certain actions that could otherwise be criminal. It pertains specifically to, and this isn't by way of interpretation, it's in the plain reading of the legislation, it pertains to school teachers and it pertains to parents by and large. And Section 43 allows those individuals, and those individuals only, to allow a reasonable force while dealing with children. And we've already in the discussion that we've had today, but I think it bears repeating around this particular amendment, because our amendment was very specifically crafted around the Supreme Court of Canada decision. And in fact, the CPC-1 amendment adopts the language of the Supreme Court. As you know, Madam Chair, oftentimes legislation in the criminal code can be challenged. Provisions can be challenged through the courts, particularly under our charter, on the constitutionality of legislation. Is it cruel and unusual punishment, for example, unreasonable search, for example? So this particular legislation, like most pieces of the criminal code, most sections of the criminal code, has been challenged. And we've seen in recent times, in times past, where sections of the criminal code have been struck down. We've seen where sections of the criminal code have been upheld. The Supreme Court of Canada, in a majority decision 20 years ago, in 2004, considered this section of the criminal code in the Canadian Foundation for Children, Youth and the Law and Canada decision. And it's really instructive and important to understand what the state of the law is right now in Canada, because when the Supreme Court strikes down or upholds legislation, that is binding on all other courts in this country when they consider someone charged under a particular section of the code. And what the Supreme Court did is it upheld Section 43. So for those that say Section 43 is unconstitutional, they're wrong. The Supreme Court determines what is constitutional and what is unconstitutional, and they found that Section 43 was constitutional. They also defined what is protected under Section 43. And I want to speak a bit about that, Madam Chair, in moving my amendment. Number one, it applies only to a parent or person standing in place of a parent. Only those individuals are justified by way of using force by way of correction towards a child. And I think there's a fundamental misunderstanding from some of the witnesses. It may be a deliberate misunderstanding or whatnot, but in Canada today, teachers cannot administer corporal punishment. This bill changes nothing in that regard. And what that means is a teacher cannot spank a child, a teacher cannot paddle a child. The Supreme Court decision found that a teacher cannot administer corporal punishment, that only a parent can administer corporal punishment. And in fact, even that is quite narrowed by what the Supreme Court decision finds, re section 43. For example, for the purposes of this section, force is used by way of correction only if it addresses the specific behavior of the child. Its purpose is to educate, correct, or restrain a child. It is not of a punitive nature. It is used towards a child who is between the ages of 2 and 12. The child is capable of learning from the use of force. So, and it's minor and transitory in nature. So some of the examples that have been used to justify this private member's bill are clearly outside the scope of this law. I'll go on, Madam Chair. Objects, including rulers and belts, are not used. So the idea that a teacher can paddle a student with a wooden paddle, no, not under this decision of the Supreme Court. It is not applied to the child's head. The mover of this private member's bill used an example in his opening remarks. So don't take my word for it. Refer back to his opening remarks. He used the example of someone punching a child in the face. That behavior is not protected by Section 43. So it goes on, and likewise, the decision goes on. Likewise, our amendment goes on, because our amendment codifies what the Supreme Court decision found. A school teacher is justified in using force towards a child under their care only. I mean, let's read what the law is, Madam Chair, because we have a lot of people making stuff up on the fly. Let's read what is the law in Canada. A school teacher is justified in using force towards a child under their care only when the purpose is to remove the child from a classroom or secure compliance with instructions, and the force does not exceed what is reasonable under the circumstances. So a lot of misinformation that's out there. Why would teachers be concerned about that protection being removed? A protection that applies only to them. It's because teachers have to use force sometimes to address behavior in a classroom. Two students kicking another student that's on the ground, beating them senseless. It happens all the time, Madam Chair. Teachers intervene sometimes in those situations. They intervene at their own risk. When you're dealing with high school students, teachers intervene at their own risk sometimes to protect their students and to protect their classroom. And what we heard from various teachers' organizations on this bill is that the safety of their classroom, in fact, depends on this section of the code, that their ability to maintain a safe environment for students hangs on this. And we heard testimony that the advice from leadership in the teaching community, the advice that they would give to teachers is, should this bill pass, is not to intervene. So in a scenario where one child is getting beaten by another child, an older child, perhaps a bigger child, the advice that they're going to give is not to intervene. Now, some of them will intervene, and some of them will be charged. And when they're charged, if it happened today and they're charged and they go before a judge, the judge is going to say, you know, under Section 43, as interpreted by the Supreme Court, its 2004 decision, a school teacher is justified in using force towards a child that is reasonable in the circumstances. Should this bill pass, that teacher will no longer have that protection. And that is why teachers took the time to leave what they were doing to appear before this committee and to provide testimony, because it was that important. That's not to mention the protection for parents against frivolous lawsuits that could be brought if a parent is now going to be the target of a charge because they're protecting their child. Abuse in Canada and has been and is rejected and is illegal. The scenario.
Abuse in Canada is not even measured. It is happening every day, all the time, because it is minimalized. We don't hear about it because it's okay. Very disappointing.
But the problem is, I mean, that stuff is all illegal. So this bill goes beyond that. And that is why it is imperative, if we're going to pass this bill, Bill C-273, that it pass with conservative amendment that maintains the protection of the constitutionally upheld section of the code. Without that protection, then teachers and parents are going to be at risk. And
Notice that he's saying teachers and parents are at risk. Oh, he finally said kids, but he didn't say them first. So let's take note on those who are at this table who are talking about kids first, because that's what we should be talking about.
getting at, but I think that and the reason I did not support Mr. Fortin's amendment is because I think CPC 1 more fulsomely follows the logic and the finding in the Supreme Court decision. I want to mention, Madam Chair, when we look at the gravity of the decisions that we're making here today, there have been 20 private members' bills or Senate bills over the years on this issue. But this Parliament and Parliaments passed in their wisdom have not repealed in its entirety, repealed Section 43. The reason they didn't do that is because of the consequences and the follow-up. And to reinforce this point, now we hear that Minister Virani recognizes that there is going to be a fallout, there is going to be consequences, and he is talking about legislation that would no doubt amend some other part of the code to be able to go to these groups, go maybe to parents, maybe to teachers, go and say, listen, we listened to you, and here we're going to do something else somewhere else in the code. Certainly not the appropriate section. This is the appropriate section. So, Madam Chair, I think I'll leave it at that for now on our amendment. But I do ask all members to consider it. If you're wondering, okay, what does it mean to pass this amendment? It means that we respect the decision that was made by the Supreme Court of Canada that really narrowed in the possible interpretation of Section 43. They took a view. They narrowed it in. They further defined what protections were afforded to teachers and parents by Section 43. I think that was very constructive for all of us, and case law has followed that Supreme Court decision. And now it is time for Parliament, if we're going to amend this section, we need to ensure that those protections that the Supreme Court put in are maintained. So I move CPC 1.
I have Madame Gladue.
Thank you, Chair. And certainly, I don't think I could do a better job of talking about the amendment than my colleague, Mr. Moore. But I would add a few things. I do like this amendment because I think it does codify what the Supreme Court decision was. And I think, we saw in the past, before 2004, we did see abuses in the residential school system, et cetera. But since this clarification and narrowing, I think we've struck the right balance and we're not seeing a plethora of cases. And in fact, I think the Teachers Federation also pointed out that having Section 43 in place with that interpretation from the Supreme Court actually is a disincentive for people to bring frivolous lawsuits. And that's important because right now,
I'm pausing this because we need to know that people are not coming forward about this because it's legal. So there is no measure of child abuse in Canada. This is not something that we can measure because people don't come forward. She doesn't know what she's talking about.
includes psychological harms that are not acceptable. And it also makes sure that the type of incident we're talking about are minor and transitory as opposed to being chronic. So I think those are also great parameters. I think
what she needs to know is mild physical assault on a child leads to conflict. Kids fight back. Parents get more aggressive. This leads to increased harm and danger and high risk for parents to hurt kids who are just trying to spank them and really hurting kids. We cannot have even mild abuse legal in Canada. It leads to way too much harm to kids and their families and communities. This is appalling that she would say so.
Madam Chair, I requested the floor. I don't know if there is a speakers list. Am I on the list? Yes? Okay.
J'aimerais qu'on continue.
I would like to continue.
Mr. Van Pop, you want to be on the list? I asked the question, though. I'm looking for guidance. Please, Mr. Housefather.
Okay, so
I just want to raise a concern that
we can continue, but if we continue, we will not have the opportunity then to go over the witness list for the anti-Semitism study. If we don't do that today and we do it on Thursday, I don't believe there will be time to invite witnesses to be here next Monday. So I just want to understand that when we do get to studying the witness list, that we're not going to just then make the study start the next day when there's no time for witnesses to be invited properly and to have that discussion, that we give time for the clerk to invite the witnesses, get them headphones, and do this properly. So I would have thought if we did this today and we resumed the bill on Thursday, we would then have the opportunity to invite the witnesses properly over the next few days and start on Monday. But I only point out that if we get to that on Thursday, we can't expect to start on Monday. Thank you, Madam Chair.
So, Mr. Moore, on the same, that's because I
Yeah,
have
absolutely.
many witnesses on, but that's a
No,
different, okay,
on-
so please go ahead.
On your point, you had indicated that we would start committee business at 12:30 it's 12:30 now. In no way, shape or form should anything that's happening on Bill C-273 impact what we're doing on our study on anti-Semitism. So I think that we should go to committee business now, and we should pick this up at some time in the future. But for now, we have an agenda for today, and I think we should stick with it, which is to go on with our consideration of committee business.
I believe it appears to be in order. I don't hear anyone objecting to that. So I'm going to ask for the 5 minutes. We need 5 minutes, I'm told here, in order to change settings, and it will be in camera. So those that are not allowed to stay, I would ask them to please leave, but I think that's what the clerk will be doing. So thank you very much. 5 minutes.
I'm not even sure how to even talk about this, but it looks like the Conservatives are, every phrase they just said in the standing committee was about protecting teachers, and protecting teachers. They admit if this Section 43 was repealed, some teachers would face the criminal code. Well, go surprise. We know there's been recent cases in Saskatchewan, in Yukon, and pretty much ask any education assistant across Canada. When teachers abuse kids in Canada, they get moved to another school. Have we heard that before? Yes. The Conservative government just now, the Conservative members of the committee spoke up about how we need to protect teachers, They also cited the 2004 Supreme Court case. They want to codify that and make amendments, which said, put in some vague rules about spanking kids, that kids have to be between 2 and 12 years old, that they mustn't be hit with an object, that it must be reasonable, that there mustn't be any frustration or anger from the adult, the child must not be with a disability, just a variety of really tedious and insidious rules on how we can legally hit kids in Canada. Unfortunately, what we know is that when there is any force, even coercive, psychological, emotional force, this leads to escalation, and the escalation leads to harm. And those adults who are dysregulated under these situations are at the most risk of hurting kids. And it's not often an intention to hurt kids at this point, it's an accident. They're allowed to spank them. They're allowed to use mild force. They do that and they rip them out. The child responds. The next thing you know, the adult reacts. So we need to make sure the law is anchored in zero violence. We need to change the norms around violence, and also make sure it's not just teachers and parents, it's all other folks who have access to children and young people too. Ultimately, children and young people have rights. They have an incredible amount of rights. And when we put these rights first, we know that their safety and well-being is first. And finally, I just want to say it's really important to recognize this is Truth and Reconciliation call to action number 6. And it is the first call to action under the category of education from the Truth and Reconciliation Commission inquiry report, 94 calls to action. And it is a symbol of Canada to repeal this and end corporal punishment against children. And this is a move towards justice for survivors of Indigenous residential institutions. And I can hardly say schools. It's also a measure of justice for myself, knowing my father experienced church abuse and that was passed on to me. It is not okay that we use any force at all. This is to look at compassion for everyone on all sides of this dialogue. Canada needs to change its position on violence and put an end to it and anchor ourselves in ending violence against children. And getting help for those adults that are breaking cycles. And our society, and actually I would say our democracy, depends on it. Thanks for those of you that have been watching, and maybe we'll do this again.